40 minutes I asked him. Thereafter, my lord, Mr. Desai is to argue on a point which I am, my lord, respectfully urging has not been referred.
Okay.
What is 197? What is the scope? The retrospectivity of Subramaniam Swami is referred, but that I'll point out when he starts. Thereafter, Mr. Datar, and thereafter my learned friend and me.
Actually, the lead matter is the appeal of the union, but I think they want us to start. The lead matter is the CBI's appeal matter, but
no, I am happy with the judgment. They persuaded the court for a reference.
Yes, yes. So I'm just saying.
I have no difficulty. Whoever
in the CBI is filed an appeal.
Yes.
Is it the CBI doesn't want to press the appeal?
No. The sequence is arranged. We were happy with the view taken. I'm not
saying a view taken by this court in before the reference, or
no. The appeal is the judgment impugned in CBI's appeal is before Subramaniam Swami.
Okay.
But my learned friend Mr. Datar persuaded the court to refer it to a larger bench, because according to him there are some issues. Otherwise, we are not saying that it applies prospectively. It doesn't apply retrospectively.
What happened was both these judgments came before the judgment of Dr. Subramaniam Swami. Then we found out that there is a judgment of Transmission Corporation, which had raised the question that if an immunity was there, can that immunity be taken away retrospectively? So what is the scope of immunities given in criminal cases vis-a-vis Article 20? Unfortunately, the Electricity Act was amended and that reference became infructuous. So then the Supreme Court passed a 2-line order saying that in view of the amendment to the Electricity Amendment Act, we are not going to answer this question. When our matter came up, I was requesting the court and I was able to persuade the court to say that this is a larger question as to what happens. And the second question also, which we said it was not exactly mentioned. The second question is, if Subramaniam Swami has struck down a law in 2014, which was passed in 2004, what happens in between to those acts which have taken place? So that's how
retrospectivity or otherwise.
145.3.
On a very simplistic notion, you begin. Is that you begin? Today you begin.
Yeah. Yes, only one thing, Dr. Kishore, he's brought, because of age and his health, he wanted.
If he wants to begin, no difficulty.
Yes, let him.
They are on the same side.
A lot of research also, so he wanted.
I would like to address this.
The only thing, we had suggested the sequence, Dr. Kishore first, then Mr. Desai, because my Lord Justice Khanna raised the question that since your 5-judge bench is constituted, let us also examine this issue of sanction. So we divided the work. Lordship said, please finish it quickly so nobody repeats. So this 197, 19, etc., Mr. Desai will argue. Then
Lord, only one thing, Lord, I must on this clarify. Lord, your Lordships are aware. The question arose whether Subramaniam Swami judgment is prospective or retrospective. Whether 6A would apply to pre-Subramaniam Swami judgments or not. Section 197, whether what is official duty, what is not official duty, Lord, that's not even referred or Lord, even dealt with by in the reference. That question doesn't arise.
Begin somewhere, we'll see.
No, I understand, Lord, but so they are seeking your Lordships.
Between all of you are good for the day. So I don't want to kill the other lawyers.
Tomorrow, yes, Lord.
At least you are good for the day.
At least, yes.
Hopefully less. Hopefully less.
So, my Lord, I would be urging, my Lord.
Hope doesn't. I often am very skeptical of these hopes. So we'll ask the other alternative matters will not be taken up today, so they may not become.
But if your Lordship sees the order of reference, even remotely, the scope of 197 is not arising.
Let us see when he begins, he'll explain how it arises.
He felt that there are some 2 different judgments, Mr. Desai mentioned, and your Lordship will not put a query. That's all. There is no reference. There needs to be some.
Begin. Please read the reference order. So start.
Let's start.
Then let's begin. So the notes also got circulated at the end.
Because there may be several judgments taking contrary view unconnected with this reference. So all will not be. We also do not know. Yesterday, very honestly, yesterday when we received a compilation of judgment on 197, my learned friend inquired from them that why 197, what is 197 scope, what is official duty? He said, no, this is also we are going to argue. That put us on a little alert that this is not even contemplated by us.
You were on alert, we got things in the morning. So we are not on alert, let us begin.
He was lucky he got it.
We have come with this one mind, clean mind.
But just for housekeeping purposes, lots of we have filed convenience compilation. I filed my compilation. Dr. Kishore wanted to file his. So if your lordship is referring to anything, I've got my volume which includes a referral order. That's one.
You can refer to the compilation. Give the compilation.
Yes. My compilation. I don't know if it's in a spiral bound or book form. It's at page 128. Yes, well,
I got pulled out of my vacation in Bombay because I was told that there's this issue which requires some assistance.
So I'll be able to satisfy Allah.
This is not on this. So I am a little
Question is,
outside.
you are usefully, productively, and in many manners, gainfully pulled out.
Yes, yes. The last part bold and underlined, my lords. By yes, emphasis supplied by me. Your lordships have the reference order.
They're just giving us the compilation which is filed, which has the reference order.
Yes, in my compilation also. There you go.
page 128. No, I'll just read the referral order, then Mr. Kishore
Yeah.
can continue.
Mr. Kishore, you have your seat, you read the reference order and then you begin.
I'll finish the referral order, and you can continue.
On mail, begin after the reference order. Okay.
No. This is index to convenience compilation. Is that what you are?
Pardon?
Are you reading? I have an index to convenience compilation.
Yes. And the petitioner is Manjit Singh Bali.
Yeah.
No, it is CBI versus Kishore.
But there are two petitions, there are two matters, one from government.
I am happy.
But that's a different matter, you know.
The lead matter is Dr. Kishore. I'm also a SLP. My SLP is there.
Lord, your lordships, only a minute. My lord, for,
What difference does it make? I think they just
Doesn't make
read
any
and see.
no, my lord, there are two orders.
Just have a seat. We'll first hear the reference order. Reference order is only one. Are there
There are-
multiple reference orders? No.
There are two, my lord.
No, actually, there's one reference order which summarizes it, and there's a reason given. That's all.
Lord, kindly see 130 of his compilation. That's the reference order. I'm not, my lord, on anything else. My lord, let us read it as it is. But my learned friend may not expand the scope. That's the only concern.
We'll see.
Yes, it's ultimately for your lordships to decide. A prosecution,
My lord, page 128.
only a minute. I'll read fully.
All right.
I'll read for you. If you want me to read 128. 128, yes.
Starts from 130.
Look, it's
The reference order begins.
120, 130.
Summary is in page 128, 129. The detailed reasons are given from page 1.
130.
It's a daily order and a judgment.
Okay.
I'm reading the longer one so that your lordship gets the entire thing.
Let us see 120. Let us have 129. Then go to 130.
129, I'll read, my lord. The provisions of section 6A1 do indicate that for officers of the level of joint secretary and above, a kind of immunity has been provided for. Whether there can be a deprivation of such immunity by a retrospective operation of a judgment of the court in the context of Article 20 of the Constitution of India is the moot question that arises for determination. For the aforesaid reasons and having regard to the provisions of Article 145(3) of the Constitution of India, we refer the aforesaid question to a larger bench, for which purpose the papers may now be laid before the Honorable Chief Justice. So this is the only question. But this is now, what I read was the summary. The detail is this one.
Detailed order.
Yes, I'll skip what is not relevant. A prosecution under Prevention of Corruption Act was sought to be questioned by the respondent accused on the basis of the provisions contained in section 6A1 of the Act, which was brought in by an amendment in 2003. 6A reads as under, your lordships can skip for the time being. The Delhi High Court, before whom the challenge was brought, answered the question by holding that respondent accused was entitled to the benefit of the said provision. Accordingly, the High Court took the view that matter required fresh consideration for grant of previous approval under section 6A1 of the Act. Aggrieved, the CBI is in appeal. We have heard. Then 4. The provisions of 6A1 of the Act has been held to be unconstitutional, being violative of Article 14 of the Constitution of India by a Constitution bench. That is Subramaniam Swamy. The judgment of the Constitution bench is, however, silent as to whether its decision would operate prospectively or would have retrospective effect. Though a large number of precedents have been cited at the bar to persuade us to take either of the above views, we would support the case of the as would support the case of rival parties. We are of the considered view that this question should receive consideration of a constitution bench in view of the provisions of Article 145(3) of the Constitution. Then, my lord, as my learned friend Mr. Datar said, in transmission corporation, the precise question that has arisen before us had been referred to a constitution bench. Paragraph 15 and 21 dealing with the said question read as follows. Whether constitutional guarantee enshrined in clause 1 of Article 20 is confined only to prohibition against conviction for any offence except for violation of law in force at the time of commission of the act charged as an offence and subject to a penalty greater than that which might have been inflicted under the law in force at the time of commission of the offence, or it also prohibits legislation which aggravates the degree of crime or makes it possible for him to receive the same punishment under the new law as could have been imposed under the prior law, or deprives the accused of any substantial right or immunity possessed at the time of commission of the offence charged, is a moot point to be debated. However, as the interpretation of Article 20 and its scope and ambit is involved in these proceedings, we refer the question formulated in para 15 of this order to a larger bench for consideration. However, the Constitution bench in so-and-so, 2010, I skip, as my learned friend said that we don't need to answer, it has become infructuous. Then 6, we have considered it necessary to make present reference for the reason that in case of transmission corporation, one of the questions referred is whether the scope and ambit of Article 20 of the Constitution of India is to be understood to be protecting the substantial right or the immunity enjoyed by an accused at the time of commission of the offence for which he has been charged. The provisions of Section 6A1 extracted above do indicate that for officers of the level of Joint Secretary and above, a kind of immunity has been provided for. Whether there can be a deprivation of such immunity by a retrospective operation of a judgment of this court in the context of Article 20 of the Constitution is the moot question that arises for determination in the present case. For the aforesaid reasons and having regard to provisions of Article 145(3) of the Constitution, we refer the aforesaid question to a larger bench, for which purpose the papers may now be laid before the Honorable Chief Justice. So, my lord, question as to whether what is the import of Section 197, whether what is the meaning of the term acting in discharge of duty, whether there is any variance between two judgments, it's not, my lord, even remotely arising. That's my respectful submission. your lordships would be considering, my lord, this reference only, because we came to know yesterday that they are going to argue something new.
No, how can we say at this stage? Yeah, the reference order is there. Let us hear what he says. This is the reference order.
Correct.
All read the reference
If
order. In that reference order, if some nuance arises, it is fine. Otherwise, this is the reference order.
yeah, yes, but that section 197, whether what is official duty, discharge of duty, that's not remotely, indirectly.
We've noted your content.
Nowhere, my lord, nowhere.
We've noted your content.
In fact, I came to know just now about this. I never knew about it.
I came to know yesterday late night, but I couldn't communicate.
As I said, you received in the night, we received in the morning. So we are a step behind you.
We are not,
That
my
is
lord, your
what
lordships
lettering
are
is
always
starting.
ahead of us. My lord.
Yes.
Please, my lord.
Yes.
Lord, can your lordships pardon my absence for a few minutes?
Yes.
My lord, I am appearing in person,
Yes.
so I show this already code that I will be brief and precise. And above all, I will be chaste in my submissions because I am appearing in person. Now, the Union of India, very rightly so, filed a very detailed affidavit in a very unusual manner against the CBI. And that affidavit was not filed by them by themselves. This honorable court, the division bench of this honorable court, gave suo motu notice to the Union of India, taking into account the fact that Union of India is answerable for the functioning of CBI as per Vineet Narayan's case, which I have quoted in my compilation. Now, this is my compilation, page 1, supplementary compilation. I think if I read it, I will be succinct in my
We
submission.
want to. This is a supplementary compilation by you.
There are two. One is supplementary compilation, which I have given just today,
Yes.
because
No, we have one. See, the whole idea of a convenience compilation is we should not have multiple papers before us.
so
We have Mr. Datar.
I will read the
Same
same
Mr. Datar's compilation, and we have what you have,
Synopsis. SYNO.
some kind of a synopsis.
Yes, that's a 5-page.
that one only. Page 25. Now, page 25 of my compilation, Milon.
Which compilation?
Page 25 of my compilation.
Today's compilation or the earlier compilation?
Today's.
This compilation plus certain factual metrics also I have given.
No, this compilation we have runs into 18 pages.
Yes, Milon. This has the case law in the first 3 pages. Then it has got certain other relevant
That's
material.
fine. Now, 25 of which, what is your referring is page 25.
So I'm reading page 25 of my compilation. What I'm submitting is
There is no page 25 in your compilation.
this compilation. This is the compilation.
This compilation has only 18 pages, which you have given
That
today.
is supplementary compilation.
I did one earlier.
Yes, no, this is the compilation.
Earlier one.
I have given the compilation, today's compilation. The detailed compilation is there. These are 90 pages, my earlier compilation.
Like.
Another one also.
This is my copy. Thank
This is the synopsis.
One is supplementary and one is main.
Yes.
So, may I read page 25 of my compilation now?
Yeah. Which begins with factual matrix of
Actual matrix and the law of the respondent's case. This is the heading.
yes.
On 27th of April 2014,
Can you please speak in the mic, Mr. Kishore, because this is a live streaming
On-
content because of constitution bench, so you'll have to speak in the mic.
can I, is it audible now?
Yes, please begin.
Yeah. On 27th of April 2012, this Honorable Court issued suo motu notice to the Union of India, which was replied by them through an affidavit served of the respondent on 25th February 2013, in which it has been categorically stated that the CBI does not have jurisdiction to initiate investigation against the respondent without the prior approval of the central government. The Union of India, after a detailed analysis, has stated that the CBI's action was illegal and the impugned judgment of Delhi High Court is fully consistent with law. The relevant portion of the said affidavit is reproduced below. It is submitted that the view taken by the learned single judge of Honorable Delhi High Court in the impugned order dated 5th October 2006 is correct and effectively captures the purpose of enactment of the provision. It is submitted that such a construction is necessary to give effect to the support to the purport of Section 6A, which is to accord meaningful protection to persons imbued with decision-making powers from frivolous and motivated investigations by providing a screening mechanism. In Vineet Narayan versus Union of India, AIR 1998 SC 889, this Honorable Court directed as below. Lord, that is why I filed a supplementary, because that thing was missed by my typist. Now I'm reading from my supplementary compilation, page 5, and I'm very sorry, page 1, for the inconvenience to this Honorable Court. So this contains the directions of the Vineet Narayan supplementary compilation, page 1.
That supplementary compilation is, I think, the same as
No, Vineet Narayan was not,
top of
I did not quote the relevant paragraph of Vineet Narayan in my main compilation. So in order to reproduce them, I filed the supplementary compilation. And on page 1 of my supplementary compilation, I have reproduced what the Vineet Narayan has said.
Yeah.
Now, in Vineet Narayan versus Union of India, AIR 1998, SC 889, this Honorable Court fixed the responsibility on the central government to ensure meticulous compliance of law by the CBI as below. There are 3. The CBC shall be responsible for the efficient functioning of the CBI, while the government shall remain answerable, emphasize answerable, for the CBI's functioning, introduce visible objectivity in the mechanisms to be established while overviewing the CBI's working. The CBC shall be entrusted with the responsibility of superintendence over it. Therefore, the central government shall take all necessary measures to ensure that the CBI functions effectively and efficiently and is viewed as a non-partisan agency. The above directions were rooted in the Honorable Court's concern for unauthorized and biased actions by a police agency like CBI, leading to unlawful and vexatious investigations and the consequent harassment to honest public servants. In order to exclude such a possibility, this Honorable Court on 27th April 2012 issued suo motu notice to the central government, which was replied by them through an affidavit dated February 2003, in which they categorically stated that the CBI did not have jurisdiction to initiate investigation against the respondent without the prior approval of the central government. The Union of India, after a detailed analysis, stated that the CBI action was absolutely illegal and impugned judgment of the Delhi High Court is fully consistent with law. The relevant portion of the affidavit is reproduced below. Para 22, it is submitted that the view taken by the learned single judge of Honorable Delhi High Court in the impugned order dated 5th October 2006 is correct and effectively captures the purpose of enactment of the provision. Para 23, the Union of India therefore prays that this Honorable Court may be pleased to read the provisions of subsection 1 and 2 of section 6A harmoniously and accord section 2 an interpretation which does not render the protection contained in subsection 1 meaningless. Subsection 1 is the rule, and subsection 2 provides an exception to the rule. Subsection 2 must therefore be given a narrow construction. The rule in subsection 1 is that prior approval of the central government is mandatory before commencement of any inquiry or investigation against an officer above the rank specified. Only in emergent situations that call for instantaneous action on the part of the CBI involving arrest on the spot can this requirement be dispensed with under subsection 2. It is well settled that trap cases form part of investigation. They involve an element of premeditation and planning, and therefore allow sufficient time to the CBI to obtain approval. Trap cases can therefore be not covered in exception provided under subsection 2. It is submitted that such a construction is necessary to give effect to the purport of section 6A, which is to accord meaningful protection to the persons imbued with decision-making powers from frivolous or motivated investigation by providing a screening mechanism. Now, para 2 of my compulsion. As such, my lord, after the above said affidavit of the Union of India, nothing survives in the CBI appeal. But the respondent at 78 years of age, with indifferent health, has been facing unnecessary litigation for nearly 2 decades, adversely affecting his noble endeavors and his scholarly pursuits, besides impairing his family life. In the circumstances, it is respectfully submitted that as far as the respondent is concerned, the reference by the Honorable Division Bench is of academic interest. However, the respondent is ready to assist this Honorable Court in that behalf, as it is always a privilege and an honor to address this Honorable Court. In the above context, the respondent is submitting additional literature reflecting on the questions raised by the Honorable Division Bench. This supplementary I find because I studied the constitutions of all countries, common law jurisdictions as well as civil law jurisdictions, and I found that except for a brief period of mid-19th century, one Englishman, William Blackstone, who wrote commentaries on the laws of England, he implanted a doctrine of retrospectivity and retroactivity, although they are two different expressions. And he said that the judge never makes a law, judge finds the law. So law existed. So where's the question of retrospectivity? Law was there, judge could not find it. So that his theory remained in vogue for about half a century. Then it was totally discarded by all common law jurisdictions, including the United States of America. And I have compiled the judgment of USA Supreme Court from 1902 onwards till date, about 50 judgments, in which all the courts have unanimously agreed that when a court finds a statute as unconstitutional, so that unconstitutionality will take effect from the date of judgment. It cannot be accorded a retrospective implication, because what has been done in the past, that cannot be wiped out. Legislation is not a piece of waste paper, one of the Supreme Court judges in the US has said. It is a law which has been passed by the legislature, and the citizens are bound to obey it. You cannot say that tomorrow this law may be declared unconstitutional. So that means if that unconstitutionality takes effect retrospectively, that means citizens are following the law at their own peril. And the law has become a Damocles sword. It is hanging on their neck. That if tomorrow it is declared unconstitutional, what will happen to their actions and their transactions? So that is why that theory of Blackstonian orthodoxy, that of course prevailed for about half a century, but it was totally discarded throughout the world, whether common law or civil law jurisdiction. Retroactivity is an anathema, and it is contrary to the rule of law, which have certain underlying values like certainty, predictability, legitimacy. So they are values. So the law will become a valueless proposition. People will not follow it. Because if I follow the law, then I have a problem. If I don't follow the law, then I am violating the law. If I follow, tomorrow it becomes unconstitutional. So where will I stand?
Sure, that's a rather expanded interpretation of it, because suppose a law is declared as unconstitutional. The court can say the judgment will apply prospectively. Court can say. Now, if that law is not supposed to exist in the statute books and is obliterated, can one say that protection of that law till it is obliterated? It may be protection, it may be prosecution, it may be anything. Everything else will survive despite the court coming to the view that the law is unconstitutional.
That is precisely the view taken. The first judgment of this Honorable Court, I have put it, 1951, K. Madhava Reddy versus Union of India. The several learned judges of this Honorable Court, precisely they said like this. And the judgment is there in my compilation. I made it, that's why I've named my compilation Factual Matrix and the Law. So I'll read the judgment, what the 1951 Supreme Court says on this very issue. That where there is absolutely no question of retroactivity. Even if there is retrospectivity, it cannot be retroactivity. They are two different things. Law can be examined from decades. Retrospectively, law may be changed, but law cannot be operated from the back. Because this is contrary to the rule of cosmic temporality. Nothing in the nature can be brought back. Past cannot be inverted. Past cannot be changed into future, neither in the present. So this law has emerged out of the natural law right from the time of Cicero, and many authorities have quoted my compilation. The question of retrospectivity of a judicial declaration of unauthorized institute does not arise, particularly in the criminal law, because many persons who were alleged to be corrupt or who were alleged to be taking bribe, they were not investigated because the approval was not granted by the Union of India. So how, if the law becomes retrospective or retroactive, how they will be caught, how they will be prosecuted? So in the criminal law particularly, the US Supreme Court said even in the civil law, the position cannot be changed, whatever action has been taken. And that 91 judgment of the Honorable Supreme Court, this court says that under Article 367 of the Constitution, General Clauses Act, Section 6 is applicable to the judicial, to this Constitution also. So Section 6 of the General Clauses Act is very clear that whatever transactions have taken place, even an immunity which has been earned, cannot be nullified by a statutory enactment. Even if the law is repealed, that law will not have effect to wipe out the past. That is the import of Section 6 of the General Clauses Act. And Article 367 says that constitutional interpretation will be subjected to the General Clauses Act. Now, I may be allowed to read the K. Madhava Menon judgment.
S.K. Madhavan, then the 15th.
As we understand, your submission is that since the law in question, as it existed, was protective of you, it's not, suppose there was a something where a prosecution is held to be impermissible in law under a statute, then we can't say that it will not operate from day one, so that prosecution ought not to have started. 66A is an example of it. But you are saying that since it is protective in nature, the law, and that protection is sought to be lifted by this judgment. Therefore, it should be interpreted as prospective. Am I correct in understanding your?
Precisely. That is my contention.
Because why I said a larger blanket is that larger cover cannot be. Suppose, as I say, some law which is prosecutive in nature is held to be impermissible in law. It can't be said earlier prosecutions will go on. See, therefore, when I said my meaning of saying extensively, we can't say in all cases it will apply. Normally, cases will apply, law will apply when it's something is struck down to the legal position as prevalent. We declare the law, unless we say it is prospective specifically. Your argument, therefore, has a nuance to it. That nuance is that this is a protective regime. And when you lift a protective regime by a judgment saying it is not valid, then that should not operate retrospectively. This is how we discussed, and I was just trying to rephrase.
In 2014 came the Subramaniam Swamy. Then it was again pending in 2016. In 2016, the Honorable Division Bench chose it fit to refer it to the Constitutional Bench. Then in 2018, the law was again changed. Came the Prevention of Corruption Act, Section 17A, which I have quoted in my compilation. And the Protection 6A was restored. So the law was in a constant state of flux. But that flux even is not applicable in my case, because I have understood the law as a student of law. After leaving my world of medicine, now I am a student of law. That the law which will be applicable will be at the commencement of list or when the matter is ripe for final decision. So which law will be applicable? The law applicable in 2004 when the case was registered. The law applicable in 2006 when the Honorable High Court decided the matter. The law in 2007 when the CBI challenged that it do not. The law in 2008 when the matter was ripe for final hearing. Or the law which is in existence as of today. Or the law which was in place for an intervening period of 3 years from 2014 till 2018. That too as an expression of judicial unconstitutionality, not a legislative enactment. So at all the relevant point of time, the law applicable is protection. Earlier by Section 6A, now by Section 17A. So there is no question of retrospectivity. Retrospectivity is if your lordship is deciding the case today, and if you find that the law is unconstitutional, then it will question your rights. But the law has been enforced at all relevant point of time. Now, so that is my perception that retrospectivity is not applicable in this case. This case is a clear-cut case of applying the law which was applicable, which was in existence at the relevant point of time. And there were 5 relevant points of time. The time of registering the case, the time of judicial pronouncement of the High Court, the time of challenging by them in the SLP, and the time when the matter was ripe, and the time when today, when the matter is being heard.
Some of them, Mr. Kishore, with due respect, will not be relevant. Mere pendency of case, what happens in between, etc. We can't take all those timelines. We have to take timeline as per the law. You can contend that the law is it stood at that stage of time, required some things to be done. And second, you can argue what is the position of law today. But we can't take intermittent stages and say, well, this was in a state of flux, so Supreme Court was debating on it, so this was being done. So these are not 5 points of view.
That is precisely my point, that if in intervening period the law changes for a small period, the law before and the law as today is the relevant law, not the law which was not there for a brief period. The legislation
That we understood.
in Subramaniam Swamy, one more additional point. What did this honorable court said in Subramaniam Swamy? Subramaniam Swamy, they said, we are not against the protection. Because in Veera Swamy, they have unequivocally said that the central government employees as well as the judges, they do require protection. But they said that you have extended this protection to a particular class of people. That is the joint secretary and above. That is discriminatory and that violates Article 4. So that needs correction. So legislature corrected that in 17. They said that now the protection will be applicable to all government employees regardless of their level, rank or position, and even to the retired government employee, public servants. So that error has been corrected. Now I have a plethora of cases which say from this honorable court as well as from the courts have thought that if an error has been pointed out by some defect has been pointed out by a court of law, and when that defect is cured, the law becomes applicable. That law gets restored. So there is no question of retrospectivity. My humble submission is this, that this reference can be answered. Of course, your lordship has to answer it. But in my humble perception, that the retrospectivity is a non-issue. And number one. Number two, for the simple reason that my appeal does not survive in view of the affidavit filed.
Mr. Kishore, confine yourself to the legal question referred for reference and not to a particular case, because otherwise it will become a very broad. We are not dealing with your specific.
Conceded. Because this question, that's why I have submitted. I'm ready to assist this honorable court because it's a profound issue. And despite the fact that retroactivity is anathema, if we see the International Convention and Declaration, Article 7 of the Convention of Human Rights, may I request your lordship to go through my supplementary affidavit because I have quoted certain constitution. It's a very brief compilation. That's a very rewarding kind of thing. I would like to your lordship's attention on that. Now, my lord, page 12 of my supplementary compilation.
Yes.
Now, my lord, this United States Constitution came about 230 years ago, in 1789.
Yeah.
Right from that time, ex post facto laws were anathema. They were contrary to the rule of law because they violated the values in which the law is rooted. And that is why the very first.
See, please, you are in a different scenario. The issue is not that the legislature has enacted something to prosecute you retrospectively. That's not the scenario. That's not the question. Issue is there was a particular provision which gave you protection. The court held that to be unconstitutional for ABC reason. Therefore, I put to you that your concern was that normally a judgment is declaration of law and would apply to all scenarios except in a scenario where the judgment says respectively.
Yes.
But your argument was that since it was a provision protective in nature,
Yes.
therefore declaration of law subsequently should not deprive you of the protection. So how I put it. The second question I'm putting to you, not second, but as your submission, as I understand it, that well, on the law being so declared by the court, the legislature in its wisdom decided to cure what was perceived as a defect in the law, which caused the law to be declared ultra vires. And that curing process having taken place, this becomes more of an academic interest. This is the second proposition. Again, I say, have I understood you correctly?
100%, absolutely, my lord. Your lordship perceptivity is profound. May I say,
Get what you are saying, that's all.
you see, my was respectful perception. Now, my lord, when I read page 82 of my compilation, main compilation.
Yes.
Now, this here, I have delineated the emerging principles. As I have culled it out from various pronouncements of this Honorable Court during last 70 years, from 1951 till 2021, as well as the decisions of the US Supreme Court of Canada, then the European Court of Justice, Supreme Court of South Africa, and various other jurisdictions. And Lord, these are the emerging principles from those judgments. As your Lordship just now said, that unless the judgment says that this unconstitutionality which we are declaring shall take effect retrospective, it cannot take. So this is the principle emerging out of.
Court declares law. Court declares law. If it feels that this law should be applicable prospectively, then it declares and says the law will apply prospectively. That is the principle. Otherwise, it's merely court is not saying prospective, it declares the law. It says this law is good, bad, indifferent, whatever. So, I'm not saying that law will apply prospectively and it will not apply retrospectively is the principle. No. The principle is that law will apply as declared. But the court can deal with scenarios which may arise, say this law will apply only prospectively.
140.
And please see that you are in a situation where you have a protective umbrella which is sought to be lifted. But there may be far egregious and grievous situations where the methodology of prosecution or who can be is declared ultra-virus. Can we say that people who have been prosecuted earlier will continue to be prosecuted and only future prosecution will not be done? How can that be? That cannot be a scenario. So the declared law will apply unless set prospectively. Therefore, I phrase the first question in your view was, you felt that this is a law which should be interpreted as prospectively because an umbrella was sought to be lifted of protection which was in your favor and it should not be treated like any other position. Number two, that there was a hiatus period because of which when the judgment was in, where the law was what you claim to be in a state of little flux, because earlier the protection was there, then the protection was lifted, then the protection was brought back. You say, well, the protection having been brought back by the legislature and its wisdom now, how can what happened earlier effective? I'm trying to pinpoint these 2 points in the conspectus so that we keep it in the domain. Otherwise, certainly nobody can bring law. All these judgments of courts are court, nobody can bring in law. It will be very difficult to sustain it, I would say, if you prospectively seek to prosecute somebody for offences created now. That would be a questionable issue, at least. That is not the scenario here. That's all I'm saying.
Lord, that's one respectful submission, your Lordship. That when this doctrine of prospectivity came in the Golak Nath case, that was the first time in 1967. And in that judgment, they have quoted a number of American authorities and pronouncements in jurists. And thereafter, the Honorable Court came to a conclusion that prospectivity is a valid doctrine in certain situations. Now, thereafter came R.C. Cooper's case in 1970, the banks nationalization case. And the judgment of 11 learned judges of this Honorable Court ruled that act nationalizing the banks was unconstitutional. Now, the question immediately arose before the bench as to what will happen to the past transactions. There has been a lot of financial activity. And so the judges, in order to combat that complication, they have mentioned in the concluding paragraph, which I have quoted. So, in case a retrospectivity is desired, that has to be expressly stated in the judgment. That is the law, not the prospectivity. If the judgment is silent, for example, in Subramanian Swami's case, the judgment says it is invalid, does not say it is void. There's a difference between validity and invalidity. Void means empty space. It does not exist. It has disappeared. Validity means that that thing is existent, but it is not operational or enforceable. So the law exists, but it is not enforceable because of the finding by the court. So it can be revived, just like a person lying on a ventilator. So the law is under ventilation and it will be revived. So, my lord, in that judgment,
Law doesn't remain ever on ventilation. Law is as it exists and recognized. Yes.
Lord, if a law is declared as unconstitutional,
Then there is a,
To
that
certain
law doesn't
effect.
exist. That doesn't exist on paper.
that law remains on the statute book, but it is not enforceable.
Doesn't remain on the statute book. I'm sorry. It doesn't remain on the statute books. Once it is struck down as invalid, it stands as if it never existed. It stands obliterated completely.
So, my lord, on that, I would like to quote 3-4 authorities.
Do that.
With due respect to the lordship's perception, I will quote few authorities on this. As to
Show
what
me
is the
any authority, show me any authority which says even after declaration of law
yes.
as invalid, that law continues to remain on the statute book. That is
Yes.
what you are saying. Please tell me if it says so. We are always in a process of learning. I'm willing to learn.
राइट दे दीजिए इसमें से कंपाइलेशन दे दीजिए 5 कंपाइलेशन जज साहब को दे दीजिए 5 का सेट है ना इसका 4 वॉल्यूम
We will look at one compilation which has been filed and the 3 compilations which we have.
without the judgment of the USA, Canada, France,
Law development in India has been so much. Why do you keep going to all over the world?
Oh, okay, it's not right. Then I don't sign it.
Yes.
I don't sign it. But I will only
Sure to us from the law developed over the last 70 years that the proposition is that once a law is declared is invalid, it still continues to be in the statute book. That is what you contended.
Yes.
Please show to us one judgment of this court.
yes. So I will
Either one judgment is good enough or 20 judgments are not good enough.
yes, my lord. I'll cite 2 judgments of this only.
Correct. This we have categorized as prospective overruling. This volume which you have given us is prospective overruling, which shows prospective overruling can take place. Certainly,
Yes.
you are saying there is an implication that any law which is struck down is only struck down prospectively, without saying so. This is what I understand.
Mentioned in the judgment that it will take a retrospective effect. And this is mentioned in the judgment that this unconstitutionality which we are declaring will have a retrospective effect. That is what Cooper says. R.C. Cooper says, I think. Lord, para 60 of my, page 60 of my compilation, we would like, it was page 60 of the first paragraph on this page. In accordance with the opinion of the majority petition, petition number so and so are allowed, and it is declared that the banking company's acquisition and transfer of undertakings Act 22 of 1969 is invalid, and the action taken or deemed to be taken in exercise of the powers under the Act is declared unauthorized. My respectful submission is that by this judgment I have learned that if retrospectivity is desired, that has to be expressly stated. This is the message flowing out of this judgment. That is why I made this submission. Otherwise, there is no need to add this clause. Once they say that that act is invalid.
We can't read a judgment like a statute. The difference between a judgment and a statute. We have to construe the logical meaning of the language of the judgment, which says that it is declared that the banking company's acquisition, transfer, and undertaking act is invalid.
Yeah.
Now, once it is declared invalid, the court went on to explain, says the action taken or deemed to be taken is there. Once it is declared invalid, anything done under invalid law is bad. That's all.
We can't read into this judgment and saying that till we declare that earlier actions were invalid, that's not, the judgment will be always prospective. That's not the ratio of this judgment. That's not the ratio of this entire flowing from this judgment.
Below.
Sure, that's why I said your best case forward is only this, that this was a protective measure available to you. And since the protective measure has been declared as ultra vires on a principle of discrimination, and the legislature in its wisdom brought it back with removing the discrimination and in fact expanding it, it should not be lifted in the interregnum period. This is the only argument which I feel can be made subject to whatever is.
We want one more.
Yeah, and one more thing you must remember. Once court holds that law in Constitution, the Article 13 clause 2, it becomes void. It becomes void.
That's
So you can't say that a law which is declared as void will continue to be valid for a specific period, though it is in violation of Part 3. You can't say that.
below. Below, in that respect, I made a very respectful submission with all humility.
We are also conscious of the anomalous situation which is flowing from it, that there was protection earlier, then there was no protection, and there is extended protection again. It's not that we are not conscious of the scenario which emerges.
It was continuously changing. It was in a flux, coming and
Never in a flux. I'm sorry. Never in a flux. It was a protection available till the court said it's discriminatory in character. Because it is discriminatory in character, it was struck down. So it got removed. But then the legislator removed the discrimination, brought it back with an, if one may say, an extra vehemence by expanding not only to all kind of officers, but also giving protection to retired people. So it was a larger extent. Therefore, I don't know how many cases are there, only for the interim period would remain. Most of the other scenario would be over because the protection is available. After that, the new protection came in, that protection is available prospectively. The protection which was earlier was there, as you said, many cases would have availed of that protection. Correct. But at some stage, between the judgment in Subramaniam Swami's case and the new law being into force, there was a little hiatus period of time. And the complication arising from that hiatus period of time, we'll have to deal with.
that is during that hiatus, the law was different. Before that, now it is
The same. You are right. You are right with that.
So for that hiatus period, all that has been granted earlier, all that has been undertaken earlier, cannot be erased. That does not stand operative.
As my brother put it, it is difficult to say that a law which is treated as violative of equality and is discriminatory can be held to be only applicable prospectively. It's difficult, especially it's not said. So it will be very difficult to say. But let us say that we understand the problem and try to see what is the why media to be found out of the problem, where a law is declared unconstitutional as violative of Part 3 on ground of discrimination. That discrimination is removed by the legislature and a new law brought into force. But in that process, some 3 years elapsed. That is it.
That is the situation. No, we not just few lines more, just few lines, just few seconds. Page 59 of my complaint.
Yes.
Second paragraph on page 15. It is also unnecessary to examine the further argument. This is the case of Madhava Mehta 1951 Supreme Court.
We are reading now page 60.
59.
1951
Yes. Yes.
SCR.
No, what we have page 59, that was R.C. Cooper.
The second, just
A
before asking.
Madhava Menon versus the state of Bombay.
Just above it. It is the next.
So I am reading one of the paragraph from the judgment which I have quoted here.
Oh, so you are reading actually what starts at 57.
Yes. I am reading which starts from 57.
You're reading part of that.
Yeah. So I can read it from page 57 itself.
No. Read it from 59. I was identifying what you are reading. Certainly.
59, page 59, second paragraph. It is also unnecessary to examine the further argument of the learned Attorney General that in case since 1868 in this country, the rule of construction of statutes is the one laid down by Section 6 of the General Clauses Act 1868. And that though, in express terms, that statute may not be applicable to Article 13(1) of the Constitution, yet that is a rule of justice, equity, and good conscience, and has become a rule of common law in this country, and should be applied even to cases where statutes become void by reason of their being repugnant to Constitution.
Sir, this judgment will not apply. This is under clause 1 of Article 13.
13(1), 13(2), 13(1).
Between 13(1) and 13(2).
Yeah.
13(1) will apply to a law which was very much valid till 26th of January 1950. Because there was enactment of Part 3, it became unconstitutional.
That's right.
And in that context, the entire discussion proceeds. But we are dealing with 13(2), where a law is enacted when Part 3 was in force.
Milo.
That's the difference between the two, 13(1) and 13(2).
Milo.
So this entire discussion in the context of 13(1).
That context also.
Because the Supreme Court says here that that particular law was valid, even tested on the basis of 1935 Government of India Act.
Sorry, that is a factual scenario of the states.
And the other proposition is.
But subsequently, subsequently, A.K. Gupta 1997.
Deals with law which was valid till 26.
Becomes a part of the common law, therefore it's.
Subsequently, in 1997, A.K. Gupta versus the state of UP, that also I quoted. They have said that while interpreting the unconstitutionality of a statute, no distinction can be made whether the law under challenge is the one before introduction of constitution, that is whether it's under Article 31 or 32. The same principle will apply to both, because Article 367 does not distinguish. Article 367 of the Constitution says that the General Clauses Act shall be applicable to the interpretation of the Constitution, just like it is for the interpretation of the statutes. And that has been quoted by A.K. Madhava Menon in 1951. And that led me to think that since General Clauses Act grants immunity to the past transactions, and the Honorable Supreme Court says that General Clauses Act is applicable to the interpretation of a constitutionally void peculiar statute, so that led me to think. Now I am reading the relevant paragraph of A.K. Madhava Menon, 1951 Supreme Court. This is paragraph 58 of my compilation.
Yes.
Paragraph 58, page 58,
58.
page 58, paragraph 2, the quotation. The High Court took the view that the word void was used in Article 13(1) in the sense of repeal, and that consequently it attracted Section 6 of the General Clauses Act, which Act by Article 367 was made applicable for the interpretation of the Constitution. Then another paragraph, the same judgment. Persons, now I'm reading on the same page, page 58. 1, 2, 3, 4, 5. I'm reading fifth paragraph on page 58 from Madhava Menon's judgment. Persons during the continuance of the statute obtain rights under it cannot be affected by a declaration that the statute with effect from a certain date will become an inoperative statute. Necessity of introducing a saving clause, it does not need the aid of a legislative provision of the nature contained in the interpretation of the General Clauses Act to hold that a prospective declaration that a statute is void affects pending cases is to give it indirectly retrospective operation, and that result is repugnant to the clear phraseology implied in various articles in Part 3 of the Constitution. When a statute has been in operation, say for 50 years, people have suffered penalties under it or have acquired rights thereunder. The law has been enforced by courts, and for such a long period, then to say that when it is repealed, it is obliterated and it never had any existence and was never passed in Parliament is rather saying too much and is ignoring hard real facts and amounts to shutting one's eyes to actualities of the situation. It would be more consistent with reason and justice to say that the law existed and was good at the time when it was passed. So, my lord, this is what the message going out as a young.
That's all? Again.
And as I said in the beginning, my lord, in view of the affidavit filed by the Union of India, so my case,
We are conscious of
they are not challenging the judgment of the Honorable High Court. They have conceded that the judgment is fully consistent with law. So this appeal is unfounded. The appeal does not survive because the Union of India is answerable for the actions of the senior. And shoe motor notices are issued to Union of India by this Honorable Court. And Union of India said that they are not interested in contesting it because the judgment is fully consistent with law. Where is the illegality in the judgment? Impugn judgment. So why should we contest it? So what remains in the appeal against me, my lord? That's why I submitted that for me, as far as I am concerned, it is of academic interest. My appeal does not survive.
Thank you.
Thanks, my lord.
Who is next in the line for you? Where does it arise?
I have in your lordship's hand because I was
Doesn't-
recording because
No,
I announced that your lordship wanted to
I,
go into the question.
being the final court and being Constitution Court, I think it would not be advisable also to get into academic areas. Because then what happens is some things are, law is created on economic.
I have only come since the court on this question.
So really speaking, if you can bring it within the four corners of the question reference made, it's fine. But if you are going to expand it and not within the four corners of the reference made, why should we go into it?
I think it won't be fair for me to even attempt because your lordship, the reference is only on.
That's what I thought.
Say, and I don't think it's proper for me to expand and try and stretch an argument.
You can enjoy your vacation in Delhi.
I'm sorry.
You can enjoy your vacation in Delhi.
Yes, who's next? Yes.
It is wrong. My lord, as a lordship rightly put it, there is a practical difficulty recognized by courts that the law is valid for a particular amount of time and then it's declared invalid. And courts in England, courts in India are all grappled with the question what happens to that declaration of the law. Now the difficulty arises where the judgment is silent on its operation. If the judgment says that this will operate, it will not affect past acts, it's all right. But the judgment doesn't say so, then what happened? That is a major problem. Now, the point arises because of the use of the word void in 13.2. That's how the problem starts. And if your lordship sees 31 and 32, I'll just give a broad outline of what I'm going to submit and I'll come to you with the points. When the draft legislation was being made, they said that insofar as pre-constitutional laws are concerned, to the extent they will be consistent with party, the law shall stand abrogated. The word used was abrogated. That's furtherly consistent in basic capacity and abrogated. But insofar as post-constitutional law is concerned, they use the word, the extent of inconsistency, it will be wide. Ultimately, in the meeting of 8th October 1947, when the final draft was made, 13.1 and 13.2 both use the word void. Now, the legal jurists, Sir William Wade and English courts have held that the word void and void are voidable, are imprecise terms. And the difficulty of using the word void in a public law statute is that we mentally try to bring in concepts of contract law into the concept of void ab initio and so on. However, the difficulty arises because in the judgments that are given, when the lordship declares 6A to be invalid, what is the impact of the judgment? Does it mean that 6A was never valid from the date it was enacted? Does it mean it was invalid from the date of the declaration? Or is it possible to have a wide area where the courts have now introduced the concept of the second actor, theory of the second actor, where by a declaration, the law is invalid. I'll come to obliteration later. The law is invalid. It is invalid in law, but it exists in fact. So there are articles which I have set out and well recommend articles saying that this is the metaphysics of validity. In law, there is invalidity. The law is not there at all. But in fact, it was there. Now, how do you solve this particular problem is the main question. And there is one judgment of the English court which recognizes this problem. They say for England it doesn't arise, but for countries having written constitution, this should be a practical problem which the courts in that country must resolve. That's the problem. Now, what has happened is this. The question referred to is in the context of Article 20, in the context of immunity. Now, I will submit two basic questions arise. If your lordship holds that the protection of the 6A was in the nature of an immunity, was in the nature of a protection, then will your lordship read that protection into Article 20? I would further go to say that 20 should not be read in isolation. 20 should be read with 21. These articles go together. So, reading 20 and 21 together, 6A is an immunity, and the lordship rightly pointed out. 6A did not come in 2004. From 1969, we had a single directive where we could not proceed against people above joint secretary records certain prior approval. That was relatively valid but invalid by beneath on the ground. You can't do it by a directive. There is no statutory provision. How can you do this by a directive? Then they introduced an ordinance. Then they introduced the Act. Lordship will see from 1969 to now, last 55 years, except one period of 18 months, this protection always continued. This protection always continued, and I have put it in my name. Now, when this immunity is taken away, will Subramanian Swami then say that from 2004, if it is invalid, if it is obliterated, quote unquote, the law never existed? What happens to all those cases where the sanction was granted, not granted, etc.? That is the problem the lordship is facing. So there are two parts to it. One is the lordship holds that 20 relative to 21 grants an immunity, and that immunity cannot be taken away retrospectively. If that responsibility, if that protection could not have been taken away retrospectively by the legislature, Can we interpret the judgment to take away that immunity retrospectively? That's from the context of 20. And then the larger question, if a lordship wants to answer it, I leave your lordship. I am going to request the lordship to hold my humble submission that whenever the court declares a statute to be unconstitutional, it is my humble request that the lordship, based on the law, that the court declaring the law to be invalid, maybe the High Court, maybe the Supreme Court, could also point out what will be the effect of its judgment. Because there are so many cases where the whole thing is completely unknown. I'll just give an example. In Tamil Nadu, if your property rent was more than 400 rupees, rent tax protection did not apply. You have to go for a civil suit. That law came in 1960, section 10(3)(3). In 1986, the Supreme Court struck it down saying that how does it make a difference? Every tenant is entitled to protection, violative articles. Now, the rent act of 1960 struck down in 86. If a lordship is obligated, never been accepted, what happens from 1960 to 86? Take a criminal law, Mitchell's case. Did not the IPC said if you are a right convict and you commit, then death sentence is mandatory. Honorable Supreme Court held that this is completely unconstitutional. You can't say that the person serving life imprisonment is a separate class and therefore deserves no mercy at all. That was struck down. Now, 302 was there in 1860, IPC. Struck down in 1983. What happens? So, my lord, this is called rightly mentioned. There could be different considerations in a taxing statute, different considerations in a welfare statute, different considerations in a criminal statute. So, the point they are making is, wherever the law is intended to protect, preserve fundamental rights, if there is some taking away of that right, it is challenged. And if a lordship then strikes it down, as the general rule, the liberty should go from the beginning, is my humble submission. But if it is creating some impediments, and it is retrospective, that also should get retrospective. But if I am getting some protection, say for example, suppose there is a law which says that if, unless your income is more than 3 lakhs, you should not be punished. Suppose the court strikes it down. Then I would say it is prospective because all along people, smaller SSCs will not be prosecuted. That is the law. So, the Lordship Commission shall I take 23 first and then go further? Yes.
Whatever you want to see.
Yes.
That's why I did mention that, or also that while interpreting, we'll have to see what is the consequence of a protective law which has been struck down. It will be different from a prosecuting law which is in struck down. Yes. One. Number two, if a protective law is struck down, some consequences may arise, and you feel that the consequences should normally be enunciated by the court while striking down the law. Worth examining. The second aspect is also that why it was struck down. In this case, and honestly, it's troubled me. It's struck down because it is discriminatory in character. So, violative of Part 3 as brother. But that discrimination is removed by bringing in a new law into force. The legislature also in its wisdom thinks that protection should be there. But since it granted protection to only a particular class of people, it says now we'll widen the protection, remove the discrimination, and go it beyond even the retired people. So, when that law comes into force, it will have application from that date of the law. So, people who may be falling in any of the categories will get protection. Now, there is a hiatus period, you say that was 18 months or 2 years or whatever it is, when till the law was enacted and it was struck down as how should the court read it?
Correct.
This is why I'm posing it is because I think you can you should endeavor to answer this conundrum and see and assist us. How should an interpretation like this take place?
In fact, I think I think because every time the judgment is struck down, then what happens? And I'll also deal with the situation of arbitration. In fact, when I was talking to Mr. Desai before he was saying that this kind of protection to civil servants is there from the beginning. It's not that it has come with a single directive. The IPC had the provision of sanction, criminal procedure for that sanction for very good. The idea is the public servant should not be harassed. If it's a thing, he should not be subject to direct police inquiry. Some filtration mechanism should be there.
Also, were we to agree with you, how should it be done? What is this?
Yes, I agree. I've written a lot of research on this.
It's difficult per se to say. This is why I put Mr. Difficult to per se that if a provision is struck down, it will not apply retrospectively is very difficult to accept. It will apply prospectively if it is said so. Otherwise, it will apply. The law will be obliterated. Prima facie is subject to voting. But there are, as you said, there are different nuances. What happens when a protective law, that too on a criminal side, is removed? And removed why? Because it is discriminatory. This is what it is discriminatory, and that discrimination is removed. To some extent, it is academic in character because it's possibly arising only how many cases of those kind are pending now, which were within that window of time between the protection being granted. In that sense, government is not really so much
But they
concerned.
didn't give an affidavit. But what I thought is the lordship decided a constitutional question. And it goes back to the regular bench, then not that bench to deal with that issue. Because they gave an affidavit that in this period there are 197 cases, in 110 we gave sanction, we didn't give sanction, etc. And the court wanted that particular bench, it came first before the two-judge bench before they reported it. They didn't have it. And lordship is one very subtle point lordship can ignore. What happened in the lordship declared a statute to be unconstitutional? My humble submission is that the law is not taken away from the statute because what the scholars have said is removing a statute once enacted is a function of the legislature that can be done only by repeal. But you will see, you normally repeal a statute, you omit a section. Suppose the main act continues and you omit certain provisions, then there is a omission of that section or repeal of that particular section. When the whole statute is repealed, we use the word repeal. What the courts have said is the court merely says this section, this statutory provision is ultra vires part 3. It need not be part 3. Today it can be a violation of 265. It can be 286.
Declaration of law. That's right.
It's constitutional limitations. They give constitutional limitations. And the further difficulty, as my friend also pointed out, your lordships for the last 3 years, we just don't have express fundamental rights. We have got derivative rights now. So many rights have been read into 21. My lord judgment in privacy, where is privacy? Lordship is in privacy. So we also have got derivative rights. Now,
and we've also said that these rights evolve. We can't today specify what it is because.
Yes. So I want to see the article 20. I'm going to make some submissions because I'm saying, please see article 30. It says the extent of contravention, it is wide. Now, what is the meaning of the extent of contravention? Lawrence writes in his book, he says the constitution can be taken to 2 ways. It is self-operative. The law is violating Article 14 is what I am issue. Now, it could be egregiously wide. Suppose we tomorrow say that any person below the height of 6 feet can't apply to the police, you strike it down. It's egregiously bad. But suppose it's a law which requires interpretation, which requires consideration. Now, 6A law ask the question, why was it struck down? The referral order said, referral order didn't talk of classification. Referral order said, can we strike down a law on the ground of arbitrariness? That was a reference to the judgment in many states. The referral order which Subramanian Swamy was there was only on the ground that the arbitrariness can be a ground for striking down the law. But ultimately, the bench struck it down on classification.
On discrimination.
Yes. The forbidden bench can strike on a different ground. There's nothing wrong with that. So that's how it actually went off. Because in the arbitrariness was answered in share among the case in a different situation altogether. So please see Article 30. Let's start with Article 30. Major only has some written submissions.
Yes. Mr. Datar has written submissions.
He began well by saying that whenever step by step, decided by the power under one body, if you the council would be occasion, it could be more difficult to know if this stops.
Yes.
Yes, but although the only one question will be referred, I have submitted the corollary question that we are also to argue that determination, because I think now with this a lot of clarity is required on the point. What is the effect of declaring a particular judgment as unconstitutional? So this is
That in any case, in some way will arise from it.
Yes.
There is
Yes.
what you are saying is a consequence.
Yes.
We are also looking, when we look at prospective, retrospective, the consequence will have to be looked into.
Yes. And I think if your lordship wants to, I think more expand it. There is another side angle, what is retrospective, what is retroactive. The lordship wants to clarify that point also later, because something is retrospective, something is retroactive. There is a lot of, in fact, there is a judgment which says what is retrospective, what is retroactive. How Supreme Court also use it in a mixed sense. So in case you're not ready, that will be explained. But I already did so, this first question I should have seen. Please come to para 1.3. It is submitted that three corollary questions also arise for consideration. Whether a declaration of law is violative of Article 14 of Part 3 rights is void and issue under Article 32. What is the effect of such a judgment on actions taken or omitted to be taken during the period when the law remained in operation? And whether there is a difference between a law held unconstitutional for lack of legislative competence and a law held to be unconstitutional for violation of Part 3 or other constitutional limitations. Now, I'm going to go to 21. Now, I want you to kindly see 21 reads as follows. No, I'll finish the argument on 20, then I'll come to 14 and 13. 21. No person shall be convicted of any offence except for a violation of the law enforced at the time of commission of the offence, charge as an offence. Lordship will just mark the thing there. I'm saying that 20 is in two parts. One is no person shall be convicted, and second part, not be subjected to a penalty greater than that which might have been inflicted under the law enforced at the time of conviction of the offence. So my humble submission is 21 can be read basically in two parts. The first part is the pre-punishment stage of the trial stage leading up to conviction. And the second part is post-conviction, that is, what is the punishment inflicted, which can only arise if a person is found guilty. Now, when I read the judgment of Justice Mathur on Transaction Corporation when it was in, his lordship said that 20 grants immunity from ex post facto laws. We traditionally understand ex post facto laws to mean that you can't increase the punishment. If the punishment was 6 months, it can't become 1 year. But is that the limited scope of 20? Does 20 go beyond that? Is the question put by the Honorable Supreme Court, which was referred. And my humble submission is, though conviction means conviction of an offence, if you lordship see the marginal note of Article 20, which I didn't reproduce here, it says protection of 20, marginal note says protection in respect of conviction of offences. Protection in respect of offence of conviction. Now, can we say that the word protection in respect of conviction will mean not only the conviction should be as per the law enforced at that time, but the first part of 20 in bracket 1, clause 1, will include all the procedural safeguards that are available to an accused at that point of time. And I am supported by Justice Matthew's judgment, which says that 21 should also be taken into consideration for that particular purpose. Now, so my first submission is the first part of 20, clause 1, at the pre-conviction stage, will also include all procedural safeguards, procedural safeguards. If that can't be taken away retrospectively, then even the judgment should not be interpreted to take it away retrospectively. I'll just read my note and I'll come to those two judgments. The clause consists in two parts: trial of pre-conviction or post-conviction. The conviction of an accused can take place only by following the prescribed procedures starting from inquiry, investigation, trial, etc. If the first stages are not permitted, unless there is a specified prior clause, there is immunity from prosecution and there can be no conviction either. This immunity is entitled to protection under Article 20 in bracket 1. The marginal note refers to protection in respect of conviction. The words in respect of must be interpreted to grant protection to all existing procedural safeguards at the time the offence was alleged to be committed. See so and so. 6A thus creates an immunity or grants a protection and cannot be taken away retrospectively, either by a retrospective amendment or by a judgment declaring such immunity invalid. It will be paradoxical to interpret 21 so as to create an environment on a statutory provision, statutory retrospective provision, but permitting such deprivation by a judicial order. Not so we just put statutory provision.
Mr. Datar, 1 minute, please. Just come to the section 21.
Article 21.
Just read it slowly. The first portion, not the second portion. We are not concerned with the second portion.
Yeah, Lord President. No person shall be convicted of any offence except for violation of law and force.
Just stop here. No person will be convicted for any offence except for violation of law and force. Now, this does not talk of procedural law. If the procedural law violates Article 21 or Article 14, it's a different matter. Article 21, Clause 1 does not deal with, it's very specific. It is very, very specific. And it may have its extreme consequences, what you just said.
No,
One minute.
if you not,
So this really is talking about the substantive law under which you are convicted. Correct? As far as procedural law is concerned, now one may say, why shouldn't this procedural protection be granted to several other cases? Right not to be disturbed is still not recognized fully in India, but indirectly it's now whether we can bring it under Article 21, right not to be disturbed, is a question which may arise in some. It will arise. It's bound to arise with the law which is expanded. So, therefore, we have to be very careful when you are expanding that doctrine to include procedural law. But it's not to say that procedural law should not be fair, because that if it is unfair, it may hit by Article 21, right not to be disturbed, or under Article 14 on the ground of, to be careful on that.
may respond. Lordship is right. If you read it, literally, it's only a substantive law. But a question mark was posed by the Honorable Supreme Court in Translation Corporation.
We'll deal with it, but
No, your Lordship is right. It only talks of conviction. There is a procedure there. Procedure go to 21. But then there was a rethink by this court, which was referred to, you're now coming to your Lordship. Now come to Translation Corporation. And a very interesting observation by this Honorable Court. And then I'll take a Lordship to the judgment of this scenario. Now, this case was interesting. They started an electricity tribunal in Andhra Pradesh to try people for offences. And what was shocking to my mind was that the tribunal consists of 2 civil servants and they could conduct a trial and punish people also. So that was not commented upon. Now, Lordship will kindly see. 108 is a judgment of a division bench.
There is the first judgment.
The first judgment. This started the whole 23 discussion. Lordship will just start with page 112. In the beginning, so Lordship will know what was the conspectus of page 112. I read below page 112. This appeal by special leave has been preferred against the judgment and order dated 8/6/2001 of the High Court of Andhra Pradesh, by which writ petition preferred the respondent was allowed, and it was directed that the criminal case pending against them shall not be transferred to the special tribunal, and their trial shall continue in the ordinary criminal courts. Now, please straightaway come to page 114, which introduced a special court. And it had its own special fast track procedure. Lordship will just come to 49D1. The state government by notification in the official gazette constitutes a special court for the purpose of providing speedy inquiry into alleged act of theft of energy and trial of cases, and for awarding compensation to the electricity utility. A special court shall consist of chairman and not less than 4 members. The chairman shall be a person who has or has been a judge of a high court. And of the other 4 members, 2 persons shall be who are or have been district judges, and the other 2 members shall be persons with a degree in electrical engineering and who have held the post not below rank of chief engineer in a state electricity board, etc. Then various procedures are given, which are different from the normal procedures. Now, paragraph 15, which starts the entire discussion. But in fact, Lordship comes to paragraph 119. In fact, no, from para 8 onwards, please come to para 6 at page 116 actually. There, His Lordship starts a discussion on 21. In order to examine the contention status of the bar, it's necessary to consider the real import of the guarantee extended clause of Article 20 of the Constitution. Then His Lordship goes into 3 independent days. Then please come to para 7, where Section 9 of the US Constitution prohibits bill of attainders and ex post facto laws. And then Lordship knows the Calder versus Bull, which I will come to later if necessary. And then note they place interpretation on ex post facto laws in para 8 at page 117. It will be useful to briefly notice the interpretation based on this constitutional guarantee by US Supreme under. Then they gave what is the protection under ex post facto law. Now we are on Article 20, and after discussing the various laws in different countries, kindly now come to para 14. Now kindly see para 14, page 121. Concerned as it is with the liberty of a person, a liberal consideration has to be given to the language used in clause 1 of Article 20 and not a narrow one. The interpretation given to section 9 of Article 1 of the American Constitution by the US Supreme Court may also be kept in mind for the purpose of understanding the true content and scope of the guarantee enshrined in clause 1 of Article 20 of the Constitution of India. Now 15 is what Justice Khanna, same point is insert here. With a constitutional guarantee enshrined in clause 1 of Article 20 is confined only to prohibition against conviction for any offence except for violation of law in force at the time of commission of the act, charged as an offence and subjection to penalty greater than that which might have been inflicted under the law in force at the time of commission of an offence, or it also prohibits legislation which aggravates the degree of crime or makes it possible for the accused to receive greater punishment, even though it is also possible to receive the same punishment under the new law as could have been imposed under the prior law, or, this is important, or deprives the accused of any substantial right or immunity possessed at the time of the commission of the offence, is a moot point to be debated. So here, my lord, His Lordship flags the question: how do we interpret 21? Do we see from a narrow lens, or do we say that 21 carries within it, is pregnant with a substantial right or immunity possessed at the time of commission of the offence charged, is a moot point to be debated? The effect of the amending act on the right of the accused to prefer an appeal may be examined first. Then they go to the merits. Then your lordship will finally come to. This is the question he raised. Now, please come to para 21. Sorry, para 20 and 21. The High Court in the review judgment has held that though in view of the language of subsection 49C, all pending cases may be transferred, so no right of appeal or revision can be taken away, nor can an accused be deprived of a better procedure for 2021. Accordingly, it held that subsection 5 of 49C should be read down, whereas the pending cases nature of the Metropolitan Court cannot be transferred to the Special Court, and the writ petitioner should be tried in the regular criminal courts in accordance with provisions of the so. However, as to the interpretation of Article 20 to scope and ambit involved proceedings, we refer the question formulated in para 15 of this order to a larger bench. And now the larger bench becomes academic. Please come to page 126 and 127. In view of the subsequent legislation, namely Electricity Act 2003, the learned counsel appearing on behalf of the parties say that the matter has become academic. Accordingly, we need not answer the reference made to the Constitution bench. Consequently, nothing survives in this appeal, and the same is accordingly discharged. So, this answer to this question ultimately came now, literally 12 years later, but now this matter has come before a lordship. Now, kindly see a very important observation at page 148. As the lordship mentioned, should we look into 140, 21 also? Now, a judgment of 3 judges, and But majority is Matthew and Mukherjee JJ and Justice Beg is dissenting. And this was a case questioning preventive detention. Now, Lordship will see, as far as we are concerned, we are primarily concerned with yes. Para 21.
Which page are you reading?
Para 21. Okay. Page is 159. But they strike down the detention. And para 19. Is there. If a ground communicated with detainee, it's the fact that the detainee could have but did not ask for further particular living material, that would be relevant only for considering the question whether the ground is vague or not. Now, about para 21 is very important. And see the spirit with which they read 21. The facts of the cases might induce mournful reflection how an honest attempt by an authority charged with the duty of taking prophylactic measures to secure the maintenance of supplies and services essential to the community has been frustrated by what is popularly called a technical error. We say and we think it necessary to repeat that the gravity of the evil to the community resulting from antisocial activities can never furnish an adequate reason for invading the personal liberty of a citizen, except in accordance with procedure established by the Constitution and the laws. Now, please note, this is what I am stressing. The history of personal liberty is largely the history of insistence on observance of procedure. But it bears reading once again, beautifully put. The history of personal liberty is largely the history of insistence on observance of procedure. And observance of procedure has been the bastion against wanton assaults on personal liberty over the years. Under our Constitution, the only guarantee of personal liberty for a person is that he shall not be deprived of it except in accordance with procedure established by law. The need today for maintenance of supplies and services essential to the community cannot be overemphasized. There will be no social security without maintenance of adequate supplies and services essential to the community. But social security is not the only goal of a good society. There are other values in a society. Our country is taking singular pride in the democratic ideals enshrined in its constitution. And the most cherished of these ideals is personal liberty. It would indeed be ironic if in the name of social security, we would sanction the subversion of this liberty. We do not pause to consider whether social security is more precious than personal liberty in the scale of valuation. For any judgment as regard that would be but a value judgment on which opinions might differ. But whatever might be the impact of maintenance of supplies and services in the community, when a certain procedure is prescribed in the Constitution or the laws for depriving a person's liberty, we think our duty to see that that procedure is rigorously observed, however strange this might sound to some ears. The petition tried to release from custody. So, my Lord, I would humbly request your Lordship, since it is coming now, for interpreting 21 with 21, 20 in bracket 1 with Article 21. To say that the provision, no person shall be convicted, that process of conviction must take into account both the procedural safeguards and the other substantive safeguards, is my humble submission. And I would say don't read 21 isolation, though Justice Markham doesn't refer to 21. I would request your Lordship that the para 15 of the Transition Corporation Order, I would humbly request my Lord to say that scope of 20 bracket 1 must be read along with the right under 21 itself. If 21 is a source of derivative rights,
Datar,
yeah.
Really speaking, these observations are with reference to Article 21, not with reference to Article 20.
No,
22.
No, Lord, the point is
what? Number 2. These are two separate. Yes, there is an interplay between the rights. There cannot be, cannot say there is no interplay between the fundamental rights. But Article 20 is a very specific nature of protection. And
whatever you are arguing will not get diluted whether you bring it under Article 21. But to say that the police should not have any power of investigation or inquiry should be read into as a basic right conferred under Clause 1 to Article 20. By reading the provisions of Article 21 into 20, Clause 1, we will create a lot of issues and problems in a given situation.
No, I appreciate it. But I'm only
Because when we lay down the law, because rights under Article 21 are certainly protected, those have not been taken away. And one cannot say the sanction is a protection given under Article or inquiry or investigation which is done by a third party, that's the police, because that's where the society, because the very fact that investigation is done by a third party, not by an individual, is a protection.
And Mr. Datar, one more thing. 21 takes care of the procedural part. If procedure is arbitrary, that Article 21 protects you. And therefore, Article 20, Clause 1 remains confined to the substantive law. Because grievance regarding procedure is taken care of by 21.
It may create a lot of issues.
That's right.
It will create a lot of issues because like 1973, the code changed. There have been amendments also in the Prevention of Corruption Act with regard to substantive, with regard to the procedural part from time to time, because certain amendments were made in 1988, if I'm not mistaken.
But I'll put it this way. I would humbly request the Lordship not to read 20 and 21 in separate silos. This was done in A.K. Gopalan, and we have got the masterly dissent of Fazal Ali, who his Lordship explained very beautifully what happens if you start reading articles in separate silos. One of the finest dissents Fazal Ali is Fazal Ali's. Now, I would submit to this bench that an interpretation which advances personal liberty should be preferred to an interpretation which tries to reduce or restrict personal liberty. Now, my humble submission,
We are not saying what is being, we are not saying that these have to be read in separate silos. What is being pointed out as the procedural part is concerned is protected under Article 21. As the substantive part is concerned, it's protected. It's a very, very specific protection which is given against penalization or criminalization of past acts. It's a specific protection against which bars penalization of past acts, which will not offense at the time when.
Correct. No. So that's the whole part. In fact, in one of the seminars at Bhopal, Mr. Vikram Nath put a very interesting question. He said, Article 21 is a procedural right. How are you using it to derive rights from 21? That's a very interesting debate. 21 only says no person shall be deprived of life or liberty except under procedure established by law. How do you get right to housing, right to road, right to Article 21? But the point is, this is where constitutional interpretation matters, where the court doesn't go by the literal language of 21 and say that, look, 21 simply says no person shall be convicted. It is only confined to substantive law. That is a very literal reading. I am requesting, as Honorable Supreme Court in the Translation Corporation said, please see page 122 once again, madam. Please see page 122 once again, because this is very critical. It all depends how your Lordship is going to view it.
No, Mr. Datar, you are right to the extent that we have to uphold the liberty.
An interpretation which promotes liberty.
No difficulty on that.
Yes. Yes,
All right, you want to go back to
no, you must just saying something I mean.
No, in any case, there you are right.
Yes.
The question is, if you are protected under Article 21, should we expand the scope of Clause 1 of Article 20?
Yes.
That's the only question.
Yes, my only submission is yes. I am submitting that it should not be conviction. Especially Mr. Amit Desai, most in law more than anybody, perhaps more than me should be. That when you talk of conviction, one little way is conviction means conviction of an offense. This is an offense you are convicted. That's the end of the matter. Now, the Supreme Court says, should we rethink it? They go to the various international developments. They go to how the US Supreme Court is interpreted ex post facto law. What is ex post facto? Is it just punishment? Is it just this or is it also question the safeguards? That's why they say deprive the accused of any substantial right or immunity possessed at the time of commission. Will not immunity be a procedural part also? And also, I'll argue, as my friend pointed out, the word law in Article 13 partly, law includes substantive law, procedural law also. Why should you restrict law to mean only a substantive law is my humble question. So I'm just submitting what the Supreme Court has asked us to consider. It's time, this is now 70 years have passed. Let us reconsider the scope of 21. Lordship will kindly see. Or deprive the accused of any substantial right. My lord is right, substantial right. Or immunity possessed at the time of commission of the offence. Now, what is the immunity possessed by an accused? Immunity can be below 5 lakhs, don't prosecute. That's an immunity. Now, you can't say even below 5 lakhs from retrospective.
That will form part of the substantive law. Let's say, like in the Income Tax Act, for late filing of the return is a stipulation 1 lakh, which has continued from 1976. That's a different matter because it should have been increased. For late filing or non-filing of return, there's a immunity till 1 lakh. So that obviously is a part of substantive law. So even if we delete that section, obviously the past offences will not be covered by it. That's part of immunity. What immunity? What you are referring to here is a procedural investigation, because mere investigation or inquiry does not lead to either. It's a process of investigation. It's an embargo. It's a bar on investigation.
Inquiry or investigation.
It's a bar of investigation. It's not a finding. So really speaking, the provision here, what you are saying is do not investigate, do not inquire.
6A says that.
6A says that.
Yes. I am requesting my lord to say.
Can you say it's covered? The bar of investigation and inquiry will be covered by Article 20, Clause 1.
I am only submitting that when you talk of 20 clause 1, it simply says no person shall be convicted. And I'm submitting, if a person has got an immunity from being prosecuted unless you get a prior approval, what does clause 6 say? If your rank is more than joint secretary and above, and that was from there from 1969, you got the Santana committee, all people have said, let public servants not be harassed, therefore they issue some filtration process. They put a cutoff at joint secretary. Why? Because decisions are taken at the joint secretary level, which has got economic consequences. That's the logic. Now, my only submission is, I am only requesting the lordship to construe 6A as an immunity. 6A as an immunity.
From conviction.
No, from investigation inquiry at the very first stage itself. And that's what also discussed in Veeraswamy case, which I'll come to later. Because why in Giri Naran says that there is no inconsistency between Veeraswamy and Para 28 and this. One of the questions referred was, is there an inconsistency between Veeraswamy's case and this case? But students on the answer, there is no inconsistency. So I'm not getting into that aspect. I'm only submitting what is the meaning of immunity. If a lordship takes the Hofelden aspect, right corresponding is duty. Immunity is the opposite of privilege. Lordship takes Hofeld Q. What is immunity? The jural corollary for immunity is a privilege. But here it will not operate. In fact, one way we have addressed this article, partly doesn't contain only rights, it contains privileges, it contains immunity. So I am only submitting that ultimately lordship has to decide when you are giving an immunity to civil servants, that if you are above the rank of joint secretary, you will not be subject to inquiry investigation without the prior approval of the central government. That should be taken as an immunity, and that is entitled to protection under 21. Now, the judgment of Justice Matthew, up to para 20, he goes into the aspects of government detention, the civil supply, their diverting some essential commodities, etc. Then he comes to 21, and 21 is a passage of universal application. Not simply 20, because the judgment is in the context of what it decides. But there are certain passages of the judgment which go beyond the particular judgment, they go into the human values. And there, they go into the aspect of immunity. And there is also the same thing, if I didn't want to bring that into expanded the whole scope. Please see the dissenting opinion in Jabalpur, idiom Jabalpur. From Magna Carta, they go to and say this ultimately, what is the liberty? The liberty is a compendium of substantive rights and procedural rights. A liberty can't be just taken as substantive right. If I have got procedural safeguards, if I am above the rank of joint secretary, one filter is there. Go to central government approval. So I've made my point. I leave the lordship to see how your lordship wants to interpret it. Because look at the other way of looking at it. A person has got immunity for all these years. Forget Subramanian Swamy. Suppose 6A had given this immunity and Parliament wanted to amend the law retrospectively. I dare say that it would be a very strong case for me to argue that this immunity was given to me from 1969, made it into a statute. Statute continued for 10 years. Now in 2014, forget the Supreme Court. Suppose Parliament in 2014 said no, 6A is invalid from 2004. Retrospective amending it. I would humbly submit that the Supreme Court would strike it down, not only on grounds of arbitrariness, but on the grounds of 20 subsection 1, clause 1. You could not have even started the trial for the joint secretary. Where's the question of convicting him? And therefore, I am asking you the protection in respect of conviction. In respect of lordship interpreted liberally. Now, if a marginal note, generally not important, but if the lordship is interpreted 20 for the first time, which is the direction we want the country to go? Are we going to say 20 is just restricted to substantive law? Or is it time to say 20 encompasses all the immunities, all the protection? I would say immunity, a better word would be protection, safeguard. These are all synonyms of immunity in the context Justice Mathur has said. So immunity will mean safeguard, will mean protection. All these things are part and parcel of the 21 right. Take it as a prosperity, nobody says no.
What you are saying, Mr. Datar, is that where a court would look to uphold the retrospective action of the legislature, don't give an interpretation where the court would be doing the same thing.
Yes. The judgment can't violate Article 14 after Viraskar's case. So there was a small deviation, but that's a different. So this is my subject as far as it is. The subject to what AG says, this is a strong statement. And I'm only submitting. I didn't want to come to the lordship. If your lordship gets time to see the judgment of Justice Supreme Court in translation power. His lordship starts at page 116 and then kindly come to page 117. So his lordship starts reflecting what is this ex post facto law. Please come to page 117. Now, see para 7, section 9 of Article 1 of the US Constitution has interpreted, has adopted on 4/7/1776, provided that no bill of attainder or ex post facto law shall be passed, and section 10 of the same article lays down that no state shall pass any bill of attainder or ex post facto. The import of this constitutional guarantee was explained 2 centuries ago by US Supreme Court in Calder vs. Kaul, and lordship will just see item number 4. Every law that alters the legal rules of evidence and receives less or different testimony than the law required at the time of commission of the offence in order to convict the offender. So, legal rules of evidence. Why not we take it as protection also granted? I'm not talking section 25, 26, statement made to a police officer, etc. I'm saying the ex post facto laws, if it can go to protect legal rules of evidence, why can't it protect other immunities also granted?